rights lawyer Chel Jokno tells the magistrates of the Supreme Court, there is no other law that punishes a person's state of mind apart from the feared anti-terror law. Jokno is one of the 7 oralists for the petitioners who are interpellated by the justices Tuesday, February 2, during the oral arguments for the controversial law. Senior Associate Justice Estela Perlas Bernabe presses Jokno on the definitions of terror as mentioned in Section 4 of the law. Solicitor General Jose Calida previously mentioned that the anti-terror law's definitions are patterned after the Comprehensive Convention on International Terrorism, initially submitted by India. Jokno notes that the main difference is that the proposed convention mentions criminal acts that have intent to cause harm, while the anti-terror law mentions vague acts that have intent to cause harm. The oral arguments also focused on surveillance, one of the investigation tools of the government to prevent terrorism. During her interpellation, Justice Rosemary Carandang asks the petitioners whether the government will be able to do its job if the law were struck down. Former Bayan Muna Representative Nery Colmenares says the government may still conduct surveillance but not through the anti-terror law. In the new law, the Court of Appeal's authorization to surveil suspected terrorists can last up to 60 days, compared to 30 days in the old law. Colmenares says that even though the law requires enforcers to seek authorization from the court to surveil suspects, the courts wouldn't have standards on who need to be surveilled because Section 4 does not clearly define who a terrorist is.